Welcome everyone. In this panel we have, I think, a very balanced and very expertise panel on the very important topics that I think for the past 3 months dominated the discussion around SEPs, standards, IP, regulation. Starting from the beginning over there, Jim Harlan, he's with InterDigital licensing team. I know Jim more as a policy person for years. He's going to be one of the speakers. We have David Muus here, working for Sisvel. I think he was before with KPN, exactly, licensing manager with KPN, also experienced licensing background. We have Dave Djavaherian, I think a well-known speaker in our space, having different hats, among others, part of the IPR group. And then we have Taraneh, Maghame, who is also a licensing expert, was with via licensing for years, before that Apple and different other positions. I think a very balanced view here today, because the topic is of course controversial. We talk about SEP policy evolution, and before we go into the specifics of that, I think we should set some perspective on the evolution. And maybe Dave, if you can start, how did we get there where we are today? If you think about the past 10, 20 years maybe, can you walk us through a little bit the highlights of what happened in the world of FRAND and SEPs?
Sure. I think you mean me as Dave as opposed to David, if that's okay. I didn't want to step on your speaking. So I do like the big picture here, because we're not just experiencing the European SEP regulation draft as all of a sudden this came up and where's this coming from? We've had decades of issues and problems and controversies around standards that have led us to this point, right? Beginning, I would say, in the early 2000s, when we had the early litigations between Nokia and Qualcomm and Ericsson and some others in the space, leading into the mid-2000s to the late 2000s, when we had the beginnings of what would become known as the smartphone wars, with Motorola and Microsoft and Apple and many others fighting over 3G and ultimately 4G technologies. We had antitrust claims being brought by the U.S. Department of by the U.S. Federal Trade Commission, by DG Comp in Europe. We had settlements. We had decisions on competition law issues. We move into the middle of the 2010s, and we began the automotive wars, which we're still going through today, and we're going to have again in 5G in the very near future. We had Ford, who makes 75% of its cars in the United States, sells 75% of its cars in the United States, based on one patent held by a Japanese entity, enjoined and told that its manufacturing plant in Germany would be shut down if it didn't pay for every car sold to an American consumer, right? We've had Daimler's business threatened in Germany with injunctions, and 5 or 6 other car makers threatened with injunctions in Germany, paying rates that, I challenge anyone to talk to a car maker who has accepted one of those licenses and agree that it's FRAND. And agree that they took it because they believed it was FRAND. I don't think you'll find one. That is the background environment of disputes where the SEP regulation comes from. We had the 2017 European Commission statement on SEPs where they provided guidance. People don't seem to be listening to that guidance, and it's only natural that at some point you're going to see a effort, whether you agree with the direction of the effort or disagree with it, an effort to try to address this enormous problem, this enormous set of litigation, this enormous hindrance to innovation in the industry with regulation. And so I think you have to recognize that when the European Commission has the entire European auto industry telling them that we have a problem here, has almost all of the tech industry telling them we have a problem here, that at some point they're going to say we must have a problem here. And these ideas that everything's okay and it's all been good and people are happy, that just doesn't mix with what we see in reality and what companies and industries that matter, that employ Europeans and Americans, that invest in innovation, that invest in research, are telling to the government regulators on both sides of the Atlantic. So I think we have to put it in that context and understand that there is a problem that is at least perceived by many in the industry, and there's an effort to address the problem that is being presented to them.
Thank you, Dave. And it sounds like that you kind of described this as it didn't come as a surprise to you. But still, I think I have to say, if I read a lot of the, reactions to that policy in the past 3 months, there's a lot of criticism there. And maybe you, Jim, can you fill us in a little bit about what you think? There is a proposal out there by the European Commission, and I think it is fair to say that this is at least quite impactful if it passes the way it is. And we will, in a minute, discuss if that is a good or a bad impact. But at least it will or may change things. And what is your opinion on this? Is that, is that a proposal that you think will help solve these challenges?
So thanks, Tim, and thanks, everybody. My friends up here on the panel, and thank you for UCSD. First of all my opinions and comments are my own, should not be attributed to my company. Because sometimes I can go off the rails. So let me just respond to some of Dave's background, because we all love Dave, and sometimes he can be a little hyperbolic, and a little the whatever the Chicken Little kind of thing that the whole world's crashing on us. And so I used to work in the auto industry. I was a software programmer for Jeep engine controllers. So I have a pretty fair understanding of how the auto industry works. And they're used to standards as far as safety standards, but if like I have some German cars at home, and right now they all need brakes, and the brake systems aren't standard, right? So I got to get 3 different sets of brake pads, and I can look at 8 different manufacturers for all these different types of brake pads, and every rotor is different, every braking system's different. They're all proprietary, they're all different. So that's what the automotive industry is used to. They're used to everything custom to their specific product. When I was at GM, we would send design specs down in tier 1, tier 2, and all that stuff, and it was built to spec on up. Now, contrast that with the telecom industry. As Earl mentioned something about 500 plus standards in laptops. There's hundreds of standards in smartphones as well. But a lot of that is due to interoperability, right? A lot of that is standardized. And I think if you had smartphones that were all proprietary, they'd be a heck of a lot more expensive than they are today. So whether or not I see, the same sort of issues that Dave sees, I mean, he and I we're friends, we'll have a drink. We like each other, I'm assuming. But we just have different views, which is fine. So will the current SEP draft regulation, just draft, it's going to take a couple years before it actually, or if it ever gets finalized. Will it solve the problems? There's a lot of complexities involved in that, and they're trying to solve very specific issues with a very broad brush. And something as simple as DVB, for example, as a standard out of Europe. Well, they don't have standard essential patents. They have a negative IPR policy. So essentially, you declare what you don't want licensed. How does the European SEP regulation handle things like that? There's a question, I think, in some of the research that Tim's done. there could be tens of thousands, hundreds of thousands of patent families across a variety of technologies that don't just include, your traditional 3GPP discipline, but also, IEEE that has general patent declarations where none of them are that specific. ITU has sort of a mixture of both, and Bluetooth and all these other ones that are out there. So whether it solves all the problems, I don't know. I think it's an interesting start, but I think I'll just pause there because I honestly forgot what the original question was. Sorry about that. My daughter's calling me.
But thank you, Jim. I think you gave a good example. Taraneh, even though you are American, you've been working for American companies, you have been closely following the European discussions. I think for those who do not know that, you were among the SEP expert group people. What is your take on this? Is this proposal at least a first step in the right direction, or what do you think about it?
Thanks, Tim. Thanks, everyone. Yes, I've been involved in this issue for a number of years now, and I think Dave laid the groundwork in terms of there is a history here. It's not just a matter of there's been no consultation. They haven't heard us. We haven't had an opportunity to opine on everything that's going on. There's been plenty of opportunity, and I want to give it a little bit more context, is that, yes, historically they have heard from automotive, definitely, from the technology sector and all of that. But then they start thinking about this and saying, look at what's happened in those areas. And we have very sophisticated companies with a lot of resources, a lot of money to throw at this, a lot of experts that have had all these issues to deal with in this space. What's going to happen when we're now moving into these other spaces? They're concerned about the IoT sectors. They're concerned about, with this push for the digital economy, green economy, all of this stuff, they see these same issues potentially unfolding in these new areas too. So it's not enough to say there's no issue, industries taking care of it on their own, because they see these new industries coming into play and thinking, how can we make it a little bit easier? Maybe we can't solve all these problems, but is there a way that we can make it easier, particularly for these new industries, these new entrants, these SMEs, and them to deal with these issues when we've seen the kind of disastrous situations in automotive, in smartphones and other areas. So I think that's part of the backdrop here. It's not about going back and fixing things for automotive. Yes, we know that a lot has been done, licenses have been taken. Whether or not FRAND, that's a different issue, but there's a lot of things looking forward to, right? So they do this trying to improve some of the issues that they learned about as a result of all of these discussions, consultations, and all of these things that they had heard over the years, starting at least in the mid-2010s with the 2017 guidance that you mentioned, and then they created an expert group. So they created an expert group. For 2 years, we sat there and discussed a lot of these issues in a great deal of detail, and there were some recommendations that were made. Well, the Commission hasn't taken those recommendations and codified it or created a regulation around it, but they took it all in. They took all that feedback, and that feedback included from companies like the automotive was there, Ericsson was there, so everybody was represented in that setting. So then they come out with something that is not to the liking of quite a few folks. Well, of course, we're going to hear feedback now. We're going to hear complaints. But it's interesting, Jim, you mentioned Dave saying, I think he meant the sky is falling, basically.
Yeah,
well, I actually have been using that term to say all the people that are complaining about the regulation are saying the sky is falling. I mean, I'm starting to read articles that are tying it back to the war in Ukraine. And I mean, just everything is now being piled on top of this regulation and how the world is going to end if this regulation moves forward. But I think what we're losing sight of is that there are issues that they felt needed to be addressed. Maybe not fixed by what they've done. Maybe there's more work that needs to be done on this regulation. But they kept hearing about issues and seeing problems with transparency, with the fact that there is no certainty around who holds patents, how much of the essential patents they hold in various spaces. And it's not just about wireless. At wireless, we have Etsy database. Let's say we have a starting point for something, but there's other standards. And I don't think that this regulation by any means says that every single standard that is published is going to fall within the purview of the regulation. A lot of it has to do with implementation, right? The devil is in the details. So the way that this is all implemented is going to have a lot to say with what actually happens. But there's work to be done, of course, but there's a lot more context around it, as I think people have been saying, than what we're hearing through the dialogue that we've seen right now.
Thank you, Taraneh, to put that in perspective. Regulation is needed in situations where markets not function, right, and where there's no solution coming from the market. You, David, you've been working for KPM as a licensing manager, joining pools. Now you're with Sisvel, creating pools. And I think only in the last, 4 or 5 months, Sisvel published a 5G pool, a Wi-Fi 6 pool, and an NB-IoT pool. So a lot of solutions, I would say, given to the market for, the critical technology that we have here. So what is your view on this? Is it really needed that we need such a regulation?
Well, I think if you see what is being done with this regulation, it doesn't fall out of a clear blue sky. I mean, I agree that there has been issues in the industry, and there's been a lot of discussions about how these issues can be solved. I'm just wondering what problem really is being solved with this particular piece of proposed regulation. If we're talking about the issue of transparency, I think for us a pivotal moment was the Huawei ZTE decision. And at the core of that was give a lot more transparency in your licensing discussions. Explain the way that your royalty is to be explained, is to be calculated. Give information about your patents. Explain the way the patents are infringed, and explain the infringement. And we took that towards ourselves, and we created a lot of information about our licensing programs. And a lot of that we actually publish on our website, and the rest we provide in bilateral negotiations. So we try to create a lot of transparency, and that way try to convince potential licensees that the programs that we take, that we create, deserve a license. Now, this regulation is trying to do the same thing. So it's saying you have to provide all this information, and we're going to create this institution that's going to publish everything, and it's going to monitor everything, and we're going to do all these evaluation checks, et cetera, et cetera. And it's interesting to see that if you look inside of these regulation, you actually see that they say, well, we recognize that pools have been doing this so far, but no longer. Once this thing is going to become active, you can disregard that, and you only have to look at our European IPO to do this instead. And I think that's a mistake. I think that we are working very hard to create these pools, and I do admit that pools have not always been working. I think that this is coming back now. I think that pools are developing now, and I think that we see this in our latest 3 pools where more industry is participating in the discussion, both on the licensee and on the licensor side, so I think that's very encouraging. What I see in this regulation, that this is actually a very good chance to disrupt this process that's ongoing. We're going to see a government-created creature that is going to tell people how to share information with each other, create a database and an institute that's going to manage it, and it's going to lead its own life. And I have concern that the time that it's going to need to construct all of this and the uncertainty that's going to surround the creation of these institutes is actually going to cause a lot more confusion and more reasons for more conflict.
Thank you for the take on this. Maybe going back to Dave, and also I give you the chance, Taraneh, as well. But what's your take, Dave? Is that are pools solving that enough, or will this regulation, on the other hand, be even more confusion because there are critical voices saying not all transparency is good? What is your opinion on that?
Pools are much more a cause of the problem than a solution to the problem.
Sure.
Pools have not been following FRAND approaches. Pools have been collecting non-FRAND agreements and licenses and using the power of many to force those agreements upon industry. And so the idea theoretically of pooling certainly has some advantages. The practicality of pooling, when I deal with pools for my clients, when I've dealt with pools in my professional work, has been not living up to the theoretical idea. But going back to what David was saying, what are we talking about? We're talking about a regulation that says there's a problem here. It's kind of the Wild West. Everybody fights all the time. The licensors want more money. The licensees want to pay less money. No one knows what the right amount is. Let's just get everybody in a room and figure out what's the fair amount. And then you have to pay it. And lucky you, patent owner, you get to receive it. You get a fair payment. And licensee, you have to make a fair payment. And that's what we're going to do. We're going to clean up the Wild West and put some order and rules around here so that everybody can live and work and invent and make products and sell products and not have to spend a bunch of time and money on lawyers like me and litigation and others, but instead to spend time and money building stuff, inventing stuff, and doing good things for the economy. That's what the regulation says. It says, let's figure out how to get everybody paid a fair amount and how to make people pay a fair amount. Now, the devil's in the details. I get it. And we've got to work on how we figure that out. And that's a 2-year process, as David mentioned. I'm not saying the draft is perfect. What I'm saying is it's hard to disagree with the idea. The idea being there's a bit of a mess out there, and let's create some order so that everybody can go back to business rather than fighting about the mess. And that's also very important for SMEs and IoT and companies that cannot defend themselves. As we saw in the recent UK High Court case, you are seeing scenarios where smaller companies are getting charged exponentially more in licensing fees than bigger companies, and that's controlling access to the market and limiting abilities to compete. And that's a problem for European companies, innovation, SMEs, et cetera. I'm sorry, I didn't cut you off.
No, sorry, I was trying to cut in. So, but if the world would work out with this regulation the way that you're describing it, I think that we would be full supporters. I think the problem is that this regulation is looking at one side of the coin and completely disregarding the other side. And what I mean to say with that is that yes, this is supposed so that it's easier for people to get into a room and understand who needs to get what. But that's where it stops. The next step is, according to this regulation, that you still need to go to court to ask people to actually pay that money that you're due. And in my experience, if there is no real indication that it is a two-way street, this discussion, it's still going to be a tool that's going to be used in a negotiation to drive down your royalty. And that may be very well the intention. But in the end, it's not a guarantee that the people who actually use these technologies are going to pay as well. And what I think is going to happen is just exactly the same thing. You just have another expert group or just another expert witness, and this time we call it the EU IPO, telling you what you're due, and then you still have to go to Munich and ask that you actually get paid or get an injunction instead. And even the most willing companies can still decide to pay just one day before trial, and nothing happened. And I think that's a real problem that this proposal is just completely disregarding.
Taraneh, you have been working for Pool for years.
Yeah.
I just learned a couple of days back that it's all platforms now, not pools, because
We run pools, by the way. I mean,
yeah, but
Well,
I mean,
I don't know.
but,
Matthias was
was gonna
moderating
say-
my panel yesterday. I think you were probably a day behind. I think you've just been changed to a platform.
yeah, well,
at least to the definition of Avanci, Matthias said,
Yeah.
then we are also in the platform business.
yeah. With
Which-
one difference, we talk a little bit more and
With your
we're a little
member,
more
yeah,
transparent.
with the licensors. I got that. But at least the licensees are involved in that discussion, right? But Taraneh, what is your take on all that?
I think that if the ideal pool functioning that David was talking about, which is not the way pools actually function, if that were happening, I guess I could agree with a little bit more of what he was saying, but that is not the way a lot of pools have happened. They have historically, we've seen very successful pools historically. But right now, when you're talking about pools bringing to the table the type of transparency and the type of process that the regulation is supposedly wanting to do, that is not what is happening, because the pools are not providing, for example, I mean, you mentioned the recently launched pools that Sisvel launched, and you know, I'm very familiar with them, obviously, because I was running the wireless pools at VIA for 6 years. And you know, you have a wireless pool that launches for 5G pool that has, you know, about 1% of the SEPs represented or thereabouts. I don't know the exact number. That does not give you the transparency of what does this landscape looks like. And the argument that, well, Huawei ZTE already sets out the framework for that. The Huawei ZTE addresses to some level what should happen in a bilateral negotiation. But don't lose sight of what the regulation is trying to do here. It's trying to give more transparency to the landscape. So it's not saying, I want to help you once you're behind closed doors in your negotiation. The point here is to get rid of, to some extent, the information asymmetry that's out there. The lack of information broadly in terms of what does this SEP landscape looks like, whether it's 5G or you know, or any of the cellular standards or codecs or whatever else we're dealing with HEVC. We talked about that a lot yesterday, but it's supposed to, and again, the details are going to be very telling. It's supposed to create a situation where there's a lot more information about who the SEP holders are, what is their general essentiality rate, what is their general share of what they hold, so that before you get into that heavy negotiation, you have some sense of what is this going to cost me. That's the reason behind the FRAND determination part of the regulation. That's the reason behind the reporting of a joint reporting by licensors of an aggregate royalty that then can be challenged if others don't agree to it. So it's all about putting more information out there so that the parties are in a better position to have those negotiations, and maybe they will end up in court. Yes, I totally believe that they will end up in court at some point, but at least even the court and the judge can look at some data points that are out there and make those decisions potentially in a more informed manner rather than just sitting there listening to a battle of the experts, which is what typically happens. So let's not lose sight of the whole thing and the purpose of the thing, and just when we focus on every little detail, yes, I'm sure there's problems we can find with every provision that's in there. But again, conceptually, the intent is to go a little bit further in trying to make this a more efficient process and one that comes out with a fairer result for all.
Jim, as working for a company that is one of the most successful SEP licensors on the market, I think you also had some transparency on your website at some point about your portfolio. And do you think that what is described here, at least as an idea, could facilitate licensing, or you know, are there reasons it could not?
Sure. Yeah, it's so I mean, you're talking specifically about the Commission's SEP regulation.
Exactly, the Commission proposal.
Transparency, yeah.
Which has the transparency aspect that there will be a register of known essential patents, and you know, that's the argument that we would then know the rate at which your portfolio at InterDigital will be essential compared to others. For example, that's at least what I would envision from that information. Sure,
I understand. So I think everybody will agree that transparency is a good thing. You know, that the sort of the more information that's out there is probably pretty good. And I think, though, that the way that the Commission is going about doing it is just sort of the wrong way. They're, you know, I don't know how many people are familiar with the way the Commission works and how they go through their legislative process, but it's my understanding, being an American, not knowing the European system as well as probably, you know, Tim and some of the other Europeans here do, is that they start off with an impact assessment. And so they want to find out, well, what will this impact? And one of the arguments that was raised by the Commission in drafting this proposed regulation is that it would impact SMEs. Well, you know, when you look at the statistics related to SMEs, there is actually, it's like their patent filings have gone up, their contributions have gone up, the litigation against them has gone down. And so it's sort of, the regulation is sort of like the opposite of what the impact assessment was kind of saying, is that the SME world seems to be doing fine, and I say that I know Dave's going to disagree, but the number of SMEs that was actually polled, I think, was very small, so the sample size was super small. So there's a lot of I found a lot of fault in just sort of the foundation of the draft regulation. That's kind of point number one. Point number two is that all of the onus and burden is on the licensor. There's nothing on the licensee. So you can still have a licensee that will still sell product and could still go about their business and still do their thing, and licensors, still have to pursue that. We're the ones that still have to enforce the rights to our patents. And there's been lots of criticism on whether or not this regulation pulls that right away now from property owners. I think there was a judge from the UPC court that sort of criticized that recently. So I think the goal is noble, it's altruistic, but I think they're just sort of going about it the wrong way. To be honest with you, given that the EU is more of a planned economy versus a market economy that we have in the States, they could just tax every cell phone. That would be a simple way to solve it. Tax every cell phone that every month, you get your extra $2 tax on your phone, and then give that to a bunch of licensors, resolve the issue. So I just don't think that they're going about it the right way. It's going to cause more problems. We've seen a lot more people kind of come out about it, talk about the criticisms for the EU. And you look at the US, there was the withdrawal of the SEP sort of policy statement in June of 2022 by the USPTO, NIST, and DOJ. In that document, they argue that the courts are sort of the best way to resolve this. You have the China-EU TRIPS agreements discussions. The EU filed a paper or a complaint against China and TRIPS for their use of anti-suit injunctions. And so now then I saw recently another panel where China might be looking at what Europe does and say, hey, if it works in Europe, we're going to try it in China. And so we heard on an earlier panel that standards are going to be split apart. Well, now licensing models will be split apart. So it seems like to me that we're just, as to quote somebody else, we don't want to throw the baby out with the bathwater, that there are other mechanisms, and if transparency is the issue, then sure, maybe pools are the right answer. InterDigital doesn't participate in very many pools, but just for a variety of reasons. Maybe it's historical, but I don't disagree that pools are the sort of the anathema to the whole system. I think pools, though, generally are better off when you have like single technology solutions, like a video codec, audio codec, things in that space, rather than industrial solutions that like 3GPP offers, because some of the other LTE pools have not done well in the past. But I don't know. Hopefully,
I'd like to just one comment I wanted to make. You mentioned pools, and David, you mentioned something about the regulation not respecting pools or saying don't pay attention. I actually find the regulation is complementary of pools. Yes, there are certain requirements it has in there that if you're a pool administrator, you need to share certain information, which I don't think, pool people I've talked to did not have much of an issue with that. And I think that a lot of what is built into there in terms of essentiality checks, they did the essentiality report back in, when was it, 2019 or 20. And I certainly know when I was at VIA there, we gave them a lot of information about how pools did essentiality checks. And I think they're actually very much supportive of pool efforts. But I think the issue is that, as Jim just mentioned, InterDigital doesn't participate in much pools. Pools are very voluntary. So if you could say, we're going to create a pool and enough licensors are going to come that we're going to give the sufficient visibility and transparency for that standard and the SEPs that cover that standard, that would be one story. But pools have not been successful in a lot of these areas that have caused these problems. And because they are voluntary, because major patent holders don't typically join pools. And I know everyone now thinks about Avanci, but let's keep in mind that's
It's a platform.
It's a platform. It doesn't matter here, right? We're not going to talk about them. But the thing is that pools are voluntary, and you just have to depend on whether someone wants to join or doesn't for business reasons, as was just mentioned. But I don't think that the commission or the regulation is anti-pool. I just don't see it that way.
No, I don't think that they're anti-pool. And when we see the information requirements on pools that are in the regulation, we are quite comfortable because all that information we already make available. It's just an extra administrative burden, I guess, that this is going to create. There's something in there that I think nobody will be able to do, and that is to disclose the identity of all licensees that exist, typically because licensees insist on confidentiality. So that is something that's going to be difficult to correspond to. But what I was referring to was the register and the essentiality checks.
Well, they accept the pool essentiality checks, though, right?
Until the regulation is in force. So the regulation says that the essentiality checks, so basically what a pool does, we evaluate patents to confirm that your patent is actually essential and has a place in a pool and therefore deserves a royalty. And the regulation is saying, well, that sounds really good. What we're going to do in our register, we're going to do sample testing, basically. And we're going to do an evaluation of our own, and then we're going to draw some conclusions how many actually essential patents you have in your portfolio for each licensor. The provision also says that if you've already done this with a pool, which is quite expensive process, I think in our pools typically it's somewhere between $3,000 to $5,000 to evaluate a patent. So if you have a patent owner that may have hundreds of patents, I mean, the bill goes up quite quickly. It also takes a lot of time because we put patent attorneys on this job. Now, you've done all this investment, and then this institution comes along, and the regulation says, sure, what the pool did, that's great. We're going to recognize that, and those patents don't need to be checked until 2 years after the regulation becomes in force. So if you are evaluated in, I don't know, if you join a pool in 2027, whatever you're going to do in the pool is going to be irrelevant for the proposal. So that's what I mean with this proposal, is trying to solve a couple of issues that we stand behind. I mean, we're okay with transparency. I mean, all of our evaluation information is even on our website. But I don't think that this regulation is actually cutting it.
Well,
and with the amount of time that they spent on drafting this, I'm just surprised how unable they've been to identify these kind of issues and put it into the regulation.
I actually think that there is a rationale here that may be missed because it's not explicitly set forth in the regulation, but I've talked enough about it with folks that I kind of understand. I think, and you may or may not agree with this, but I think the goal here is to create a consistent system, right, across Europe at least. And at some point, if this regulation moves forward and if these provisions are actually put into place and there is a body within the competence center, there are evaluators within the competence center that are performing these essentiality checks, the random essentiality checks. And by the way, SEP holders can also select up to 100 annually to be checked. All of this, once this happens, I think that the purpose here is to not have two parallel essentiality check processes and to encourage pools to also work within this framework of having established a body of experts that do these essentiality checks. So that could be what you're referring to in terms of there's a lag time. So first we're going to have to go through the whole passing of the regulation, the implementation, then there's another 2-year period, and then this issue is going to be revisited. And at that point, if there is a process set up where essentiality checks are being done in a way that is consistent based on certain criteria, based on neutral evaluators, then perhaps pools can also take advantage of that process. So I actually think they're trying to build more efficiency into this. You may not agree with it, and maybe there needs to be some changes made to what they've done, but I don't think it is. The purpose of this is to say we don't think pools have been doing it right, because they've actually modeled this to some extent after what pools have been doing.
Well, yes and no. I think we're also missing a big point, which is that you want the evaluation done by someone who does not have a vested interest in the outcome, right? Sisvel would not want to outsource its essentiality checks to its licensees. It might find out that it has 3% of its patents essential and it's 97% non-essential if it were to accept those results from its licensees. Likewise, licensees rightly don't accept the evaluations that pools do, right? They're self-interested. They have a desire to have more patents so they can charge more and justify that. And their members have a desire to have more patents in the pool so they can receive more, et cetera. Any such unilateral evaluation by a party with a vested interest has to be looked upon with a little bit of suspicion, right? And so I think that as much as the regulation might want to not interfere with or override the work that's been done to date, it also recognizes that if the regulation goes into effect, people can make investments based on understanding that in the future, a neutral evaluation process may be used as an augmentation of the current unilateral evaluation process that pools undergo.
Don't we already have a neutral evaluation method in the courts?
On a patent by patent basis, sure.
Sure,
This
but-
is an effort to create a portfolio adjudication that gives a fair rate to patent holders and a fair rate to licensees on a global basis that prevents the need for fights about injunctions, right? Parties can go to a German court with different views as to whether a particular patent is valid and infringed. And even though a defendant thought that a patent was invalid and not infringed, can get enjoined and put out of business unless it pays whatever rate the patent owner asks, based on one patent, one evaluation. This is a very different process than that. It's an effort to get the whole shebang right,
But
not one at a time.
What are you saying now, that judges are not capable to set FRAND rates?
German judges don't set FRAND rates. We know that. That's what they say.
I think, yeah, maybe that German situation was also triggering that regulation to part, but still I want to go back to the point how this could really work, because I think one thing we have to appreciate, and that we heard a lot today, we live in a very complex world, right? It's not all 5G. We have, different Wi-Fi generations. We have within 5G, like different protocols like NB-IoT or LTE-M, Cat1. We have V2X, right? These are all different specifics of implementing technology in different products. And then I can tell you from my experience that every month we have a new 1,000 patents in a database of SEP declarations, potentially essential. Is that register really gonna work? Is that really something it can, or is that challenge even possible to be solved with all that? I don't want to talk about cost here, but the sheer complexity we have, is that gonna be, working out?
Well, I think, and this goes back to my transparency comment earlier. So the big issue always is, for those that don't know, is particularly when you do top down and you look at a stack. I'm not a fan of the word stack, but it's out there. Is the denominator, right? How big is the denominator? And the bigger it is, the worse case it is for you as a licensor. The smaller it is, the better it is for you. You look at the Apple Optus case that just came out, the denominator was 22,000 patent families. You read some of the documents that are out there, there could be anywhere between 75,000 and 90,000 patent families. So where is that number really? That's a pretty big delta from 22 to 90. But I would argue that, let's just argue it's a small number. Let's say it's 22,000 patent families. Sounds like a lot. But I guarantee you not 100% of the owners of those patent families are actually seeking licenses. So let's just say half of them are. Okay, now we're down to about 11,000 patent families. So the denominator's better. And of the owners of those 11,000 patent families, based on one of the slide decks that have gone around, or maybe it's one of Tim's presentations from May, I think it's 25 companies own the top 86% of all patent families. Well, let's just say 20 of those are actually actively licensing. So now we have 20 companies that are actively licensing 11,000 patent families. To me, that's more transparent as to, okay, this is the denominator, this is the share of the different patent holders, and this is what industry can expect. Those are simple things to run. But it's just that I think what is out there, there's a lot of FUD for people in the marketing industry, fear, uncertainty, doubt. And when we hear this, it's like, hundreds of standards to a smartphone, tens of thousands or hundreds of thousands of patents are out there just at Etsy itself. It's overwhelming. So I get where small companies would either not go into a certain industry or join a policy organization that wants strict European regulation on standards on SEPs to help them codify and understand their business model. But I guarantee you also at the end of the day, kind of like what we saw in the Lenovo InterDigital case from the UK, courts are going to start deciding that you need to start paying from the day you started selling product, not the 6 years back that a lot of jurisdictions do. So there's still a lot of stuff out there, but I think once we kind of hone in on a denominator, start honing in on some fundamental aspects that make good business sense, we can sort of get this closer to something that works for everybody. I personally think my tax on that monthly tax on your cell phone is the best solution because it's easy. But no one's going to do that.
We still have a proposal here. It's not even a final thing. So, Taraneh, I think you've been also talking that we may even think about, how is this going to be implemented. So would that be an idea that, let's say that regulation passes, shouldn't it be then focused on particular use cases without trying to solve everything at once? Because I think that everything at once is to me so complex that I see, that's almost impossible. Shouldn't it be almost like a pool where they focus on one technology in one vertical maybe, and get a database down there and go from there? Or what do you think?
Well, I think that's kind of built in right now because there is a process for that register to be opened up for a standard. So there could be situations where there's a standard that they don't, there's even exceptions now built in at the very last minute where they said, if there is a standard that the commission determines is already subject to efficient and reasonable licensing practices, it will not be subject to this, right? And then there's the flip side of that if there is because the regulations, keep in mind, is for future standards. It's not directed to every standard that's currently out there. But it also says if there's an existing standard that has had difficulties in licensing, that may be selected too. So it's to some extent, again, it's all about how it's all rolled out, right? Because there's a lot of flexibility right now in terms of what standards are actually going to be covered in this register and how that's all going to play out through the implementation. But I think that the whole point here is to give broader visibility, not to just look at use cases, because there's also the issue, which I think Dave can talk to us for at length, is, should licensing be on a use case by use case basis? It depends on how you define use case, right? And it's not about smartphones either. Yes, we all love Jim's idea of just give the money. We used to say this all the time at one of my places. Oh, here's the total royalty. You guys go fight over it. We don't care, right? But it's not about smartphones. It's not about, these things that we are all so familiar with. It's forward-looking. What's going to happen going forward? Now, maybe there's issues still to be resolved with smartphones as well, and automotive maybe, but that was not the point of this. The point of this was to have a system that can be helpful to avoid the issues that we've had so far in these industries that we're familiar with. So I think that there is flexibility enough to adapt it to ways that might be working. But right now we're at the point where people are saying the sky is falling, so we can't even have a rational discussion like you're talking about.
But in the end, if it's not about smartphones and automotives, which is probably 98% of all royalty income right now, that 2% is not going to solve much, right?
And isn't it that also 95% of all litigation, which is supposedly the big problem?
Yeah, but I think that the issue here is that there's a lot of discussion about new pools being formed, new industries that are coming into this whole connectivity play. We know that the major SEP holders in this industry are looking to these new segments in IoT that are using connectivity. Yes, the royalties are likely not going to be as humongous as we've seen in these other areas, but does that mean that those industries should not have the transparency and the ability to negotiate fair deals on FRAND terms just because it's less revenue? And if it is less revenue, and if it's not going to be harming what has already been done, why are we seeing such a backlash
I
from
think
the licensors?
I think that's a lot of speculation to base a regulation on, about a future potential conflict in an industry that hasn't formed yet, while the market is trying to figure out how to
I
deal
also
with
don't
it.
think it's speculation, because what I have found, and I know personally about this from clients that I work with, is that they have talked about these issues and they see this coming to them, but they're not willing to openly come out and discuss it. And that's one of the issues that we have here, is that's why we're not hearing from them, because they are they're having these discussions confidentially, but unwilling to actually come out and take positions like many other companies are taking. I'm just saying, these are the things that I think, as the commission was hearing this is how they got to the point we're at now. Now, you can second guess everything and say, no, you didn't hear this, or you don't have enough SMEs that you got responses from. SMEs have a business to run. I mean, that's the other thing, is when you're working with implementers, you know that their focus and their management focus is on products and running their businesses, and they often don't even have a policy person. That's why they talk to us. It's like, what do I do about this? They just are not focused on that. And were they focused enough to talk to the commission? Some were and some weren't, right?
Sure.
So this is where we are now. The question is there anything useful in this regulation that could potentially move forward? How can it move forward to help these issues? Nobody's going to be happy about it, ecstatic. Certainly not the SEP holders, and I think the implementers have issues with what's in there now too.
Yeah,
But,
I don't disagree that I mean, they always say the best agreement is where both parties are unhappy, right? But I think right now we're more unhappy. And I'll tell you, and one of the reasons is that it's a non-binding decision by the
EU IPO.
Yeah. So it's like, the EU IPO, they issue these non-binding decisions. So then once you pay all your money and you realize you get your portfolio into this platform or whatever it is, and then now you've got to, you talk to a potential licensee and you're like, hey, I'm in this. Well, the decision by the essentiality check people, that's a non-binding decision. So now you could end up going through this entire process again. It's not cost saving at all, if that's the case. And then so it's like, well, then what was the point the entire time, other than to sort of like ramp up more, another government department with more money and more spend and more red tape. And then it's like, then it takes 9 months to even get your portfolio analyzed properly. And then you can't even enforce it until that happens, if you even register at all. So now you start getting property rights taken away from you. And that's in Europe. That doesn't matter about the UK. I mean, the UK, we could just, that's different, right? And then, China's got its system. The US has its system. You've got, South America. So it's just, you've got one jurisdiction that wants to create a one-size-fits-all solution on a global scale on only European patents. And it just sounds crazy.
Jim, you now sound like Chicken Little a little bit. First of all,
well, it's fallen.
First of all, it's non-binding, but it's not non-persuasive, right? You get a rate that comes out of a decision there, and the licensee doesn't take it. I'm pretty sure you're going to be able to make good arguments that the licensee is an unwilling licensee, right? Likewise, if the patent owner doesn't take a rate, the licensee is going to feel pretty comfortable that even if that rate is found not to be right, they're acting in good faith by agreeing to accept that rate. But let me give you the alternative, because the regulation is only as good as what it's replacing, right? What's the alternative? What is the world we live in today? The world we live in
Sunshines
today
and rainbows.
is in Europe, right? And I'm not talking about the UK system, I'm talking about the European system. In Europe, you can take one patent, go to one court, find that your offer wasn't wildly inconsistent with FRAND, and use injunctions to set rates that the licensee does not agree are FRAND, and that the court never adjudicates to be FRAND. It's not a good process right now where all the litigation goes before a few judges in Munich and injunctions are used to force an entire industry to pay rates that everyone in that industry believes are non-fair. That's not the right solution. That's not a good process. We've already had Motorola, DG Comp. where DG Comp said using injunctions to force rates is not the right thing to do. We have Huawei ZTE, which has a process which I think many have argued is not fully being followed by some of the member states, right? We have US FTC and DOJ guidance that injunctions shouldn't be used to force FRAND licensing, right? We have processes that are better than the injunction-focused process that's currently being used. And I think that folks that are afraid of a rate-setting process are enamored of using injunctions to enforce the rates that they want and not have someone looking over their shoulder and telling them objectively whether that rate is FRAND.
Yeah, I mean, I don't know. I mean, in the U.S., we have eBay since '06, and so it's almost nearly impossible to get an injunction on any patent case anymore. A, B, Oppo did get I think Nokia or someone got an injunction against Oppo in Germany, and so Oppo, I believe, pulled out. But I was just talking to somebody the other day, and they were in Germany. They wanted to see how easy was it to get an Oppo phone, and they got one delivered the next day. It came out of Italy, but my point is that if the industry, and based on we have this whole topic of digital convergence, right? I mean, that's what sort of killed the camera, and now it's all digital and it's all on our phones. But if the concern is Munich in Germany, and
it's a concern.
It seems to be the biggest one that you mentioned. So I'm just going to focus on that though. But if that's the concern, that a judge in Germany believes that party A, offered a license on fair terms and party B rejected that, then maybe party B should be enjoined. I mean, even though party B thinks it's unfair, it's not the right rate, it's $14 and it should have been only $4. Well, reasonable minds can disagree, but I mean, that's all part of the legal process. That's why we go to court, to resolve disputes, right?
Yeah, I mean, I thought a party that agreed to have a rate setting process was sort of by definition a willing licensee, and that sort of process that the European government is seeking, the European Commission is seeking to establish, would allow companies to say, I'm going through this rate setting process. And if they disagree with it, go to Germany, seek your injunction, all of those things. The practical reality is that injunctions are being used to force people without a rate setting process to pay rates that they objectively in good faith believe are non-FRAND. That's how we're setting rates, and that's how we're getting licenses today in the industry, today in the telecommunications industry, today in the automotive industry. That's the leading sort of approach to how to get licenses. It's not particularly effective or fair or rational, and so trying to substitute that process with a better process, I'm in favor of. Now, I'm not saying nothing's wrong with any draft regulation. Of course, we can make it better and we can tweak it, but let's look at what it's replacing. You mentioned eBay. American law these days is becoming irrelevant, and I think that's a problem, because if you just go to Germany and sue Ford and get an injunction despite the fact that they make most of their cars and sell most of their cars in the US, and that they're going to lose $1 billion, $2 billion, $3 billion by having a factory shut down in Germany if they don't pay for cars sold in America, you've now made American patent law and American patents irrelevant, because whatever an American court says doesn't matter, right? In the UK High Court case, the patent owner in that case argued that the pending US case, where the defendant had filed a rate setting case in a United States court, should be ignored, that the UK court should set the rate for the US and not leave an adjustment clause in place to adjust that rate if the US court came to a lower conclusion or a different conclusion than the UK said. That was the argument the patent owner made. I can't think of a better example of US patent law becoming subservient to, dependent upon, and I use that word on purpose, a foreign patent law than that example.
I think that you're overestimating how many licenses are actually determined by litigation. I think that there's way more licenses being closed without litigation, and what we actually see in the in the courtrooms is that it's just a bunch of companies that are revolving door clients. I mean, there are these companies that just follow a strategy of efficient infringement, and they decide to go to every court and wait out as much as they can and try to obtain that way a competitive edge over their competitors. And especially when we're talking about IoT, I mean, we're engaging in IoT now, and there are some willing companies out there that want to resolve it. We're talking with them, we're trying to figure it out. And we actually come to a point now where we say, well, we think that we may find what is a good royalty approach here. But I know that about half of my competitors are not going to pay. They're going to wait for 2 years, or they're going to eat up my market share because the people who buy my products are killing deals based on cents, not even on dollars. And that is a real problem. And I think that
Wouldn't the SEP regulation fix that?
No, because the SEP regulation is just going to tell you how much needs to be paid by whom after a process of about 2 years, and then it's redundant by the time that you get the outcome, because already Tim has 10,000 new patents waiting in line. So that's not really going to solve it. And nobody's telling anybody that guy that's actually still holding out and taking the license, that he actually has to pay up. I still need to go to Munich to get that done. So I don't think that this is going to solve the real problems that we have. I mean, I agree, transparency is good. I just think that this is the wrong way about it, and it's not solving one of the bigger issues in the industry.
I've said it before, I will say it again. I represent and have represented over the course of my career a lot of clients. I've talked to a lot of folks who aren't my clients, who have been on what we'll call the licensee side. I have never in my career experienced a client who said, I agree that those patents are infringed and valid. I agree that the rate that they're seeking is FRAND, but I still won't pay it. Every single dispute that I see is based on a client who says those patents are junk or those rates are absurd. And those are the causes of the disputes. Not some guy secretly hiding in their closet saying, ha ha ha, I'm gonna keep all my money. It's real, actual disagreements in good faith by patent owners and by licensees. Patent owners tend to overvalue their patents, licensees maybe tend to undervalue, and that creates good faith disagreements. We need a better system to solve those disagreements than if you don't pay what he asks you, I'm putting you out of business. That's not a good system.
Well, also it doesn't put them out of business. Maybe they need to reevaluate and adjust their margins and then pay in. They rightly violated a property right, and to substitute the violation of the property right, pay the fee.
Yeah.
But
I mean,
who
that doesn't put
determines
somebody
the
out of
fee? I guess
business.
the issue really is when there's a disconnect as to what is the fee that should be paid. That's
Sure.
the issue, right?
Sure.
So you're saying, well, just raise your price, pay the fee. Well, maybe your fee is wrong. So this is the whole issue. Is
Well,
there a
yeah.
process that can resolve that part of it? Because someone may say a fee that's too low, someone may say a fee that's too high. That's the issue, the asymmetry of information here, including lack of visibility to comparable licenses. That's another issue. That's a big thing out there. That's something that at least was in some draft of the regulation. I feel like there's been some changes lately that
Yeah,
maybe
there's a leak
took
in
a
there.
little bit. Yeah, there's like 3 leaks. But there was the requirement at some point, I think it was an initial version, where you needed to provide information about your comparable licenses to the competence center and to the conciliator and so on and so forth. So, and then people refer to this at the EU IPO. I refer to it at the competence center because it's not the EU IPO. That's the body under which the competence center is going to be created, and that competence center is going to have its own governing body that's going to be appointed based on their expertise and so on. So that's the difference. I never say that EU IPO is going to do this, but there was the attempt to have more visibility even at that level, and that may or may not have changed, but we are where we are now.
Yeah.
When I set up this panel, I kind of expected there is disagreement, and as always, we can agree that we disagree. I think one common thing that I see here still is that the regulation as it is needs to be worked out more. I think we can all agree on that it's pretty vague right now, and it really will depend on how it is defined, if it should pass. And of course, that it's a European regulation and we have a worldwide licensing world is a challenge, right? We talked about this Brussels effect, and I think to make it work, I think there has to be adoption beyond Europe. Otherwise, it will not be used, I guess, or just be limited. But I wanted to the rest of the time also open up to the audience, because I think it's a very controversially discussed topic. So other comment issues we have here, Oskar, with the first question or comment.
Yeah, thank you, panel, for this very interesting discussion. Well, first, I just have a comment and then a question. The comment is just on the German system. I think it has been a little bit misrepresented. I have reviewed a lot of cases, and first, injunctions are just not granted. The court will look at whether the royalty is FRAND. They don't engage in what I call second guessing the FRAND royalty, but they will tell to the SEP holder and implementer, present me your argument. And if you look at the data, there are about 60% of the cases when they grant an injunction, 40% where they do not grant an injunction. And if the implementer says the royalty is not FRAND but comes empty with no evidence, then the court will say, yeah, well, I don't see any evidence that it's not FRAND. But I'm not sure it's completely accurate to say that they don't look at whether an offer is FRAND. And on the same time, there are cases where the court found that the SEP holder offer wasn't FRAND, and they refused an injunction. But then I saw that there was a lot of disagreement as to whether there is a problem or not in SEP licensing. And as an economist, I would say, well, let's look at the data. And the Commission has asked for a report to be produced, and it had excellent authors, Tim Pohlmann and Justus Baron. It's publicly available, and they have looked at FRAND litigation over the years. And it's a public report. I encourage everyone to read it if you haven't. And basically what they found is that FRAND litigation was going up until 2014, and then it decreased dramatically. And in 2021, it was a year with the historical low number of litigation. They also looked how does this litigation compare to patent litigation generally, and they found that the share is decreasing. So there isn't really evidence to say, oh yeah, there is a lot of litigation, there is a problem. So I just wanted to hear what is the view on the panel on this. Is there really sufficient a base to say, yeah, we really need this regulation that will change?
What she said.
I lived through it. I talk to clients, and it's not just the cases that are filed, it's the cases that aren't filed. Do you think there's like an automotive maker that didn't notice that Ford was enjoined in Germany? Do you think there's an automotive maker that didn't notice that Daimler was enjoined in Germany, or that the European Commission didn't initiate an action against some of the licensors? The hammer of an injunction, the death knell of an injunction, casts a long shadow. And I haven't combed through the very extensive, long report that Tim prepared with Justus for the European Commission. But I would look at those figures a little bit differently, and in view of my experience in working with clients in the industry who are very conscious of sort of how things have been playing out.
It sounds as if you're trying to say that patents are just a bad idea in general.
Not at all. Of course not. I think, as I said,
I mean,
we
the
should
threat
figure out
of
a way.
using your patents is basically.
We should figure out a way to get SEP holders paid, and we should figure out a way to get SEP licensees to pay, and that's what the regulation is trying to do. Fair rates, fair results, no threat of market exclusion. I proposed when I was at Broadcom in 2013 that we replace the current system with a system that includes attorney's fees, interest, right, all the costs of delay, and use that as a replacement for injunctions, so that a licensee would know that if it held out, there was no gain in it, there was no profit in it. A patent owner would know that if they were faced with holdout, they would get every single penny they deserved. And you know who opposed that? It was the patent owners. They wanted their injunctions. They didn't want the monetary compensation to give them a court-set rate as well as all the costs of delay. They wanted the injunction hammer to get them what they wanted outside of the court system.
Let me just add here that the Commission, I think, is thinking, whether you agree with their approach or not, that providing a more efficient system that gets you to your money faster is also good for the SEP holders. Now, you may not agree with the steps they took to move in that direction, but I really hated that everyone thinks that, oh, they just did this for the implementers, that's it. Because that was by no means, I don't think that, based on the conversations I've had, the intent here, the intent was if the system works better, the SEP holders don't have to litigate as much. The negotiation time could be, I mean, I've been involved in major negotiations that took 4 or 5 years. We can cut back that time to money, basically, and that will help everyone on both sides. Again, the thinking is that whether you agree with this approach is a different story.
Yeah, I think Terry Breton had a different perspective. I think he was really anti-SEP holders in his speech that he gave for 45 minutes, railing against us.
I think he said, we're going to bust that practice.
Yeah.
I wish that had not been the case, but
Yeah.
you also have to understand that he's not the one that wrote the regulation or spent hours and hours
Sure.
reviewing the feedback that the industry, hundreds and hundreds of comments and feedback that the industry submitted to the commission throughout these few years. Right?
But I actually think that we're
One more
agreeing on
question.
a lot of topics about transparency and that it's good. I mean, I even like the idea of a neutral competence center evaluating patents if they would be doing it in a fast and efficient way and 100%, which we're doing in pools, for example, because if you don't do 100%, it doesn't mean anything to us because that's how we divide money. But what you're just saying, I mean, that additional cost, I mean, I would like to look into what you were proposing at Broadcom because I like that kind of stuff. I think that makes a lot of sense, but that's not in the regulation. I mean, the regulation doesn't talk about how the licensees are actually then also are held to pay their fair share.
Right.
One more question here, John.
Yeah, tell me if this is a dream. Keep the registration system, keep the aggregate royalty determination, but prevent implementers from introducing products that utilize the standards until that process is complete. So then they know what the overall royalty is going to be. They can price that into their products before they put them on the market. Is that going to work?
So a pre-injunction. An injunction
Essentially, yeah.
before,
Then
an injunction in advance.
You're sort of balancing it, right? The implementers aren't allowed to just introduce those products without having paid for the IP.
That seems like a terrible idea.
Why?
From
But tell me why.
the idea of promoting market promulgation of standards, encouraging next generation technologies, protecting consumer interests and having access to next generation standards, and ensuring that whatever price is paid is a fair price for all parties on the front end. Delaying market entry by 2 years so that this process can go forward seems bad for the economy and consumers and businesses and standards bodies, et cetera.
And I think part of the thinking there has always been until they understand what the implementations are, it might actually be difficult to determine those rates. Like you're basically determining an aggregate rate in a vacuum. Some aggregate rates may be based on use cases, some categories. And that's why there are details of the provisions that say if you have an aggregate rate after the standard is adopted based on known implementations, and then when you have new implementations, you have a certain period of time to announce aggregate rates for the new implementations if they are in a totally separate category. Right. So all these things have been kind of thought about, and there's a reason behind the way it's kind of put together right now, but it's just maybe rushed and doesn't fit as well as it should.
We're a bit over time. We have one final question, and maybe the answer to that pretty short, please.
Yeah, on that point, so I do VVC video compression stuff. So part of this is we don't know what's essential because the stuff is pending right now, right? So if I'm making my decisions of implementing VVC today, I don't need more transparency because
There's a lot of issues, though, aren't there? I mean,
well, here's the thing. Every contribution to the standard is published for video. All the inventors' emails are on the standard. You can literally email anybody who's proposed anything.
right.
If a client came to me and said, hey, what's this landscape look like? And I couldn't tell them, I'd hire Tim. And if not, I'd be
that data.
I'd be incompetent, right? So it's a chicken and egg thing, because Dave's got it right. It's about royalties, but we're saying, hey, I need more transparency, because someone could sneak out of nowhere and have all these patents, and I mean that's not going to happen, quite frankly. And to the extent it does, I mean, that person is an innovator, right? And number two, the essentiality determination, does it lower your rate? Part of it is built into the royalty rate, right? So if I license all of Qualcomm's video patents, okay, 90% are essential, 10% are essential. It's baked into the rate, right? That's part of the market efficiency. So that was the point. It's like, part of the patent pool is, I don't want to go through every single one of your patents to determine which are valid, which are essential, but I'm paying this rate, right? It's like buying a box of old CDs. There might be some good ones in there, might be some bad ones in there. You don't get to go through it, right? And if you want to, you can, but
I think, I mean, EU law or general competition law, you cannot bundle like patents together. They're not essential, so there is a legal obligation to claim trade them, right? I think that's even, you're forced to do that. But I mean, I agree. We know licensing is licensing of portfolios, and it doesn't matter if you file a patent in the future; it will be part of that license, same as some expire. But I think we are, unfortunately, over time. I think this is a super exciting discussion that we can continue later over drinks. But we have a few more. One keynote and one more session here. But I think thank you for your question from the audience. Thanks, panel. I think that was a very sophisticated discussion, very detailed. Little less of the big picture we heard this morning, but even more expertise here. So thank you for participating, and thanks for your expertise.
Thank you.